If a transaction's form complies with the requirements in a tax avoidance statute, is that enough to trigger the statute's tax avoidance benefits? Or must the transaction's substance also match that form? The United States Supreme Court addressed this question in Gregory v. Helvering. Evelyn Gregory owned all the stock in United Mortgage Corporation. United owned Monitor Securities Corporation stock, which could be sold for a large profit. If United sold the Monitor stock itself, it would pay tax on that sale and could distribute any remaining profit to Gregory as a dividend. Gregory would then pay a second round of tax at the ordinary income rate that applied to dividends. In that scenario, approximately $30,000 of the stock sale proceeds would go to taxes. Alternatively, United could give the Monitor stock directly to Gregory as a dividend in kind for Gregory to sell. In this scenario, Gregory would pay taxes on this dividend at ordinary income rates, which would result in about $20,000 of tax. Ultimately, Gregory chose a third option. A tax statute made corporate reorganization transfers tax-free. This statute's purpose was to allow entities to change form without having to recognize tax consequences. The statute defined what transactions qualified as reorganizations. Relying on this statute, Gregory had United create a spin-off corporation called Avril Corporation. United transferred all the Monitor stock to Avril and all of Avril's stock to Gregory. This transaction met the statute's technical definition for being a tax-free corporate reorganization. A few days after Avril was formed, Gregory dissolved the company. Avril liquidated its assets, distributing its only capital, the Monitor stock, to its only shareholder, Gregory, who then sold the stock. Because Gregory had received the stock as a distribution of Avril's capital rather than as a dividend, Gregory paid taxes on her gain at the tax rate for capital gains, which was significantly lower than the tax rate for ordinary income and resulted in around $10,000 of tax. The Commissioner of the Internal Revenue Service, Guy Helvering, determined that although the spin-off's form met the reorganization statute's technical requirements, the transaction wasn't a true reorganization. Instead, what the transaction had truly done was distribute United stock asset to Gregory, which was the definition of a dividend. Thus, the Commissioner taxed Gregory at the higher ordinary income rate for dividends, and Gregory owed additional taxes. Gregory sued, contesting the additional taxes. The Board of Tax Appeals found that Gregory didn't owe additional taxes because the transaction had technically complied with the reorganization statute. The Second Circuit reversed this ruling, finding that the reorganization statute didn't apply because, in substance, the transaction wasn't a true reorganization. Gregory appealed, and the United States Supreme Court granted cert.